नहमदुहु व नुसल्ली व नुसल्लिम अला रसूलिहिल करीम फ़अऊज़ु बिल्लाहि मिनश शैतानिर रजीम बिस्मिल्लाहिर रहमानिर रहीम। लर्न लॉज एकेडमी यूट्यूब चैनल के मुअज़्ज़ज़ नाज़रीन, लॉ ऑफ टॉर्ट्स लेक्चर सीरीज़ के आज के थर्ड लेक्चर में थ्योरीज ऑफ लाइबिलिटी को डिस्कस करूँगा। Whenever a wrongdoer commits a wrong and harms the victim, and the victim comes before a lawyer for the legal advice, then the lawyer must ensure whether the wrongdoer will be held liable or not. If the claim is filed before the court, the judge must ensure whether the wrongdoer or defendant will be held liable or not. This is the foremost duty of a lawyer or judge. So, for the determination of liability, law of torts guide a lawyer, a judge, and here the law of tort provides certain theories which determines the liability of a wrongdoer. So, the topic theories of liabilities under law of torts is a very important or beneficial one for the law students, lawyers and judges. So, there are two theories which are applied for the determination of liability under law of tort. First is fault theory and second is no fault theory. According to fault theory, until the fault of the wrongdoer is not proved, he or she cannot be held liable. Means the determination of liability will be on the basis of the fault on the side of wrongdoer or defendant. Now the question is, what is fault on which the liability of the wrongdoer is based? Basically, fault refers to guilty mind of wrongdoer. There are certain mental conditions which are responsible to the fault. These mental conditions are intention, motive, malice, etc. There are certain torts for their commission or completion. Fault is treated as an essential element. Such torts are known as torts based or intentional wrongdoings or intentional torts. For example, there are certain tortious acts or act of torts which can harm or which can affect human body. For example, tort of assault, tort of battery, false imprisonment. So, these torts are intentional torts because of the act of battery, act of assault, false imprisonment never can be completed without the element of fault. So, in these acts of tort, fault in the form of intention, motive, malice is an essential element for the completion or commission of tort of battery, assault and false imprisonment, etc. For the determination of liability in such type of torts, fault theory is applied. Fault theory is always applied. That is, proving fault in the form of intention, malice or motive is necessary. Otherwise, wrongdoer cannot be held liable. So, in these types of torts, the determination of liability depends upon the fault on the side of wrongdoer. So, in such type of cases, for the determination of liability, plaintiff have to prove the fault on the side of defendant. In the absence of fault on the side of defendant, on other hand, there is no fault theory, which is also applied for the determination of liability of defendant or the wrongdoer. This no fault theory speaks about even no fault of the wrongdoer or no fault on the side of wrongdoer is he can be held liable if he legally harms the victim. In cases of fault theory, plaintiff have to prove fault of defendant or wrongdoer. The fault may be in the form of intention, malice or motive, but in case of the no fault theory, there is no need to prove the fault on the side of defendant. Only certain situations or conditions are required. If the defendant has committed a wrongful act, has committed an act of tort, he shall be held liable even without proving his fault. For example, the situation where we apply rule of strict liability, rule of absolute liability. So, in such type of cases, there is no need to prove the fault on the side of defendant. He or she can be held liable even without fault on his or her side. Till the rule of strict liability came into existence in 1868 in case of Rayland versus Fletchur, and which was evolved by Justice Blackburn, the basis of liability was fault, or the courts applied the fault theory in case of Tajer versus Child, which was decided in 1857. The court refused to provide remedy to the victim only when he could not prove the fault of the defendant, because till this time the determination of liability was based on the fault. But later, when the court evolved the rule of strict liability, which applied in certain conditions, where if a person brings or accumulates certain things likely to cause damage over his land, and those things escape and cause harm to someone, then the person who brings or accumulates certain things over his land, he or she keeps those things at his own risk. If the things escape and cause harm to someone, The person who brings or accumulates those things shall be held liable to compensate the victim. In this situation, there is no need to prove the fault of the person who brings or accumulates those things. If the conditions or situation is same as was in case of Rayland versus Fletchur, we can the court can apply the no fault theory for the determination of liability of the defendant to provide a remedy to the victim. Somebody is suffering a loss of right or injury, the defendant can be held liable even without fault. In such type of cases, the court applies no fault theory for the determination of liability of the defendant, and without fault the defendant can be held liable with the help of a rule of strict liability, rule of absolute liability. There are certain act of torts where fault remains an essential element for their commission. So, in such type of cases, if the tort is not completed without element of fault, there the court cannot hold liable a defendant or wrongdoer without proving the fault on his or her side. In other cases which resembles to the situations like in case of Rayland versus Fletchur, c.Mehta versus Union of India, where the Supreme Court of India in 1987 abolished the rule of absolute liability. So, these rules can be applied in certain kinds of situations. If these rules are applied for the determination of liability, there is no need to prove the fault on the side of defendant, because of only certain situation if is existing, the defendant can be held liable even without proving his or her fault. In this manner, the determination of liability becomes on liability without fault, or in such type of cases the courts applied no fault theory for the determination of liability in situations where we apply rule of absolute liability, rule of strict liability, and these torts, such type of torts fall into the category of tort based on unintentional wrongdoings. One of the important point is here, what is fault? So, fault refers to the guilty mind, to the guiltiness of mind. There are certain mental conditions which forms the fault, like intention, malice, motive, etc. What is intention? Intention is a mental condition which influence a person to commit a wrong. So, whether a man or human is with intent or not, it can be determined if the person is knowing what he is doing and the consequences of his doing, and he has the knowledge of the consequences of his doing. वो क्या कर रहा है और उसके करने के क्या परिणाम होंगे. If he knows, he is with intent, he is with intention, he is committing the particular act with intention. Motive is another mental condition where with the knowledge of the doing and the consequences of the act, the person who is committing a wrongful act also has an ulterior motive. He wants some gains after doing that particular act. For example, a wish to cause death of B. He serves poisonous food to B. B eats that poisonous food and dies. The intention of A was to cause death, and the ulterior motive can be to inherit the property of B or to secure the property of B in his or her favor. A has the motive, malice in Hindi, vidvesh. With the malicious attitude or malicious feelings, if a person wants to cause harm to another person, he can be held liable for any act through which he causes harm to person. For example, if a person brings a criminal action against another person only for pushing him in troubles, there is no any reasonable ground for bringing an action against. For example, A brings a criminal action against B without any reasonable ground. B faces some hardships during the prosecution. Finally, the court acquits him. So, it was only due to the malice on the side of A. He faced so many hardships during the prosecution. Now, B can take a civil action for the civil remedy against A because of A brings a criminal action against B quite maliciously, only on the basis of malice. परेशान करने के इरादे से बी के खिलाफ एक्शन लाता है, बी के खिलाफ कोई प्रोजिक्यूशन जिसको हम मैलिशियस प्रोजिक्यूशन के नाम से जानते हैं करता है। अब बी ने जो हार्डशिप, जो परेशानियां वहाँ फेस की हैं, अपने एक्विटल के बाद में ए के खिलाफ वो एक्शन ला सकता है सिविल रेमेडी के लिए, एंड द एक्ट ऑफ ए वॉज मैलिशियस. द पर्सन हु इज विक्टिम due to this malicious prosecution can claim against the person who brings malicious prosecution and can get the remedy. In case of malicious prosecution, the plaintiff have to prove the malice on the side of the defendant. If he proves the malice on the side of the defendant will be held liable to compensate the victim. Or in case of malicious prosecution, the fault in the form of malice on the side of the defendant is an essential element for the determination of liability. Here the determination of liability is with the help of fault theory. लर्न लॉज एकेडमी यूट्यूब चैनल के नाजरीन से बहुत मुअद्दबाना गुजारिश है कि इस चैनल को सपोर्ट करने के लिए आप सब्सक्राइब करें